Good morning. The very important topic to be discussed on point of writing examination, the coming examination for judges. To understand the entirety of the case, definitely I think this a question would be asked on this particular subject. Kindly go through AIR 2023 Supreme Court 1780. AIR 2023 Supreme Court 1780 Sri Shiva Shankara versus Himachal Pradesh Veda Vyasachar HP Veda Vyasachar, not Himachal Pradesh. It is private engineer HP Veda Vyasachar. Order 6 Rule 17 was discussed. Section 107 CPC about remanding power. Section 6 for suit for possession. The main ground raised by the other side was that the property is not belonging to either the plaintiff or the defendant. They say the property is belonging to third party. So suit was not maintainable was the ground. But the Supreme Court has discussed at paragraph 30. That is most important to understand the views of the Supreme Court and their ability in rendering such judgments. It is evident that on careful consideration of the available pleadings of the defendants, the High Court held that they did not disclose their defense in their written statement, and at the same time did not even contend therein that they are in possession of suit property. According to us, in such circumstances, when the fact discloses no title in either party, at the relevant time, prior possession alone decides the right to possession of land in the assumed character of owner against all the world except against the rightful owner. In the context, it is worthy to refer the maxim possessio contra omnes valet factor here qui ius sit possessionis, that hath possession as right against all, but him that hath the very right. So except the real owner, the suit is maintainable against all. This is what they say. Several judgments were discussed. In short, the Supreme Court has held just 30, just 30, just T or TII, which in Latin means right to of a third party. So thus when facts discloses no title in either party at the relevant time, prior possession alone decides right to possession of land in assumed character of owner against all, while except against rightful owner. This is what the judgment says. Kindly go through and keep the judgment, read it elaborately. If you are really interested to get high marks or top rank in the selection process, unless and until you understand the very basis of this order 6 rule 17 matter. Best wishes. The another Supreme Court recently has given another judgment wherein also I will discuss it later on. For a partition suit, Justice V. Ramasubramaniam J. For partition suit, the title need not be looked into. The title of the property need not be looked into. That was the Supreme Court judgment. That we will discuss. These both judgments are very interconnected and important. So, whether the suit is maintainable against the third parties, or if there are suit between two parties and the property is belonging to both parties. I understand my endeavor to take this judgment. Then question arises, way in which the registry is dealing with criminal cases. I have noticed that the cause list is intelligently prepared by the staff of criminal section, allowing some uh, some of his friends get advanced preference in hearing his matter. And I understand the Honorable Mailad also noticed, and the registry is somewhat overacting. This should be stopped, it should be looked into because multi-number of cases are not reaching, thousands of anticipatory bails are pending, and what is happening I could not understand. And the representation of the state is also not seems to be genuine. There seems to be some favorable representation for some lobby advocates. This is what I presume. It may be true or wrong, but my grievance I want to share with you. Best wishes.